All righty. Good morning, everybody. It's your boy Bach. We are back. Hidden Black's Law. Quick disclaimer: our videos should not be construed as legal advice. They are merely a presentation of facts as we understand them. We are not attorneys, and you should seek the service of a legal professional if you believe that you are a victim of misconduct. The facts presented in our videos are not indicative of personal opinion, and we do not always agree with the outcomes, people, or judgments of any interactions. Um, Laws, case laws, ordinance, policies, legal doctrines, and all other information is subject to the interpretation of the courts. The legal topics covered in our videos are for educational and information and should not serve as legal advice under any circumstances. The contents of our videos is in no way intended to provoke insight or shock the viewer. We just give you information based on facts, research, as we understand them. These videos are created just to educate the citizens about their constitutional protected activities, laws, civil rights, and we emphasize the importance of constitutional awareness. So thanks again, everybody who is here and tuning in. And today, as usual, we got our two main guys that make this happen. Google in plain sight.
Morning.
We still get feedback.
It's still chopping in the background, but I heard what you said.
I'm trying to do everything possible to get this thing to
So do me a favor.
Hear me?
I heard you say "hear me."
Yeah, I just out all the headphones and all that stuff.
All right. It seems to be slightly better. Well. Oh, what? Where Bach go?
I'm right here. I'm right here.
All right, yeah. I was just going to throw out the Hale versus Hinkle joint right quick. Go ahead and read it down for the people. All right, so we said we're going to start every cast with this because, like I was stating at a point, that this is, of course, the most cited case in the court history, and it has never been once successfully opposed. So basically, as you see here, Hale versus Hinkle was decided by the United States Supreme Court in 1906. The opinion of the court states, the individual may stand upon his constitutional rights as a citizen. He's entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation, so far as it may tend to incriminate him. He owes no duty to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land, common law, long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. And yeah, the other paragraph there is just a little background on the case and how it's managed to stay relevant in the court system for so long. So that's not as relevant. I mean, but do feel free to take inventory of that information that kind of gives you the backing of the strength of this statement made by the court. All right. So I think we're ready to dig into the subject matter of today's cast. And that subject, of course, is going to be the legal concept of subrogation. And it ties back into a lot of our talks. I know we just finished a 3-part series on your private capacity versus the public. And this is basically tying in with the idea that you, as a private man or woman, freeborn, are able to wield the account that the state has generated underneath your moniker. And this will basically, what this process does is it gives you a legal remedy that will allow you to actually take back the power generated by an entity that is underneath your umbrella, since it is technically at that point, even though that account may be public, it is property of yours that the state is using to generate income. And this will basically give you a nice legal weapon to put to use at your whenever you need. Are you muted or something, Google? Oh, I thought you were saying something. So, yeah, with that, that's basically the process of subrogation. And I did shoot across some definitions so that anyone who needs to see in plain text what subrogation entails, we have that lined up for you as well, so we can understand what you're employing when you evoke it.
Can you hear me now?
Yeah, I'll make you sound really clear.
All right. Finally, I got I had to take everything off, all my headphones, everything, and just use the speaker mic for the tablet itself. I can't use anything else right now.
Hey,
what I was saying is, go ahead and read off what is subrogation in the first place.
All right, so let's see. I'm trying to decide because I actually have 2 definitions laid out. Did you happen to see those?
The ones on screen or
yeah. Well, that's the second of them. But that one kind of goes into more of a detailed nature of, the fact that there are 2 versions of subrogation. So I mean, we can rock with this one. So yeah, let's go ahead and read that out. So here you go. The substitution of one person in the place of another with reference to a lawful claim, demand, or right, so that he or she who is substituted succeeds to the rights of the other in relation to the debt or claim and its rights, remedies, or securities. That's the flat definition of subrogation. Basically, substituting out a party for another that might have equal what's the word I'm looking for? Consideration in the matter. Or like, for instance, if someone owed me $2,000 and then someone else said, "Hey man, this item costs $2,000," I would actually be able to get the person who owes me $2,000 to step in and pay that $2,000 bill due to the bill that they already have on tab with me. So in a practical sense, that's the idea of subrogation. So here it says there are 2 types of subrogation: legal and conventional. Legal subrogation arises by operation of law, whereas conventional subrogation is a result of a contract. The purpose of subrogation is to compel the ultimate payment of a debt by the party who in equity and good conscience should pay it. The subrogation is an equitable device used to avoid injustice. And that's the strength right there. Let's go on and read what's going on with legal subrogation. Legal subrogation takes place as a matter of equity, with or without an agreement. The right of legal subrogation can either be modified or extinguished through a contractual agreement. It cannot be used to displace a contract agreed upon by the parties. Conventional subrogation arises when one individual satisfies the debt of another as a result of a contractual agreement that provides that any claims or liens that exist as security for the debt be kept alive for the benefit of the party who pays the debt. It is necessary that the agreement be supported by consideration. However, it does not have to be in writing and can either be expressed or implied. So, and there's a random comment there that says, this is what you get into when you get yourself into, this is what you get yourself into in court. And that's actually that quote kind of makes me laugh. Because it's quite very much what you get yourself into when you're in court under most pretenses.
Yeah, it's I was just saying it's when they bring you to court, there is always a bond or a financial settlement on the table that you pretty much are unaware of. That bond is taken out in accordance with the name that you are get the privileges of using, and they do not tell you that that bond is technically yours to do with what you want. And so when you go into court, that bond can be claimed by them since you did not decide to say anything.
Yep.
So go ahead, talk about the trust, I should say.
All right. So basically, all as we've generally stated about all law being contract, the ultimate form of contract out here in America is the organization known as a trust. And there, in any given trust, there are three parties. You have your trustor, your trustee, and the beneficiary, who is the third party who basically is able to claim benefits from the operation of a trust partnership. So basically, you're treated as the beneficiary, but that actually the role, the U.S. government is of course the trustor. So who and the trustee would be off the top of my head. Help me out here real quick. I know who the beneficiary is.
You have the trustor is the pretty much if you want to say the magistrate. The trustee is the attorney. I would say is the best way to put it. His name is the attorney. Yeah, and because they have taken out the bond in your name for you.
And, the beneficiary is actually that account. Not so much you, the man, but you, the name on that account that they've taken out in your name. But so that's the basic trust structure.
The business name is the one that they are using in the courtroom itself. Is why they let you speak and do everything else. But like we always, everything that happens in the United States of America is a business itself, since the United States of America can only do things in the field of business and contracts. They have no claim to men or women, which is why you will never see the word man or woman in any legal documentation. It will always be person, it will be citizen, be a name in all capitals. Just like a business, a name in all capitals. It will never be in lowercase and capital. It will just be in that.
Right. Yeah, exactly. So they will always default to the idea that you're talking in the terms of the public and not accessing your ultimate claim to sovereignty.
At all times, you are just like, if remember when we read off, there was another cast we did a while back where we read the Constitution of Maryland Declaration of Rights, where it literally said in it that the men and women reside in the territory known as Maryland are the sovereigns. They are in control of themselves. There is no king or body that is claiming them. They claim themselves, and they are themselves in all that they do. There's no government that has control over them. Now, that is what pretty much sovereignty is. You are your own king. You are your own ruler. Everything that, all the rights that a king has, you have the same rights as a sovereign, because that is what a sovereign. Everyone is entitled to their own kingdom. You are in charge of you. Now, the only way they can do business with that, and how you can do business from cross state lines, how you can do international business, is you need a corporation. Because you can't, it's hard to do business when everyone has a whole different contract with the party. So you make it all one, and making it as a state or a federal government, because you need one body to represent all the others.
Mm. And yeah, that sounds very much so how you would hearken to a terminology such as uniform commercial code, as in one united fashion in which to deal with transactions in that commercial nature.
Yes. So that is where the whole subrogation comes into play, because the name, you are the beneficiary of the name of your business name. You are the beneficiary, so you get to claim all the benefits of the business name. Social Security card, that's why they tell you on the back that this is property of the Social Security Administration. It is not whoever's name is on that, since they are, that name itself is a business, is not theirs. It is the Social Security Administration's. It's not theirs. So when you are doing things as a business, that is what they are doing under, because they ask you for your name, and what they do is apply it to your Social Security card, your number, which is not another business. Everything that works in a business contract. So when you go through a court system and there is a bond, it is done so written off to the business. It is, the business has pretty much incurred this debt, if you want to put it that way. So what you can do, what subrogation does, is allows you to pay off the business debt with your business. Your business pays the debt, not you per se. Your business pays the debt. So what you are allowed to do is sign for that. What's the thing called right now? I just can't remember. It just blanked. My mind just blanked.
The bond.
Yep. The bond. You are allowed to sign for the bond. They will never tell you you're allowed to sign for the bond, and that is the end of the court proceeding, because that would be the end of the court proceeding. So they would not be able to incur or claim anything else, because you signed for the bond, so which really just got rid of the whole court proceeding itself. So there's nothing more to do, but you walk out, and they get to put the money on their books as new money in their system.
Exactly. So actually, Bot, can you do me a huge favor and repost that Yeah, the other, yeah, there we go. So this one is actually more striking. I mean, it's actually a little more plainly put. I mean, the other one kind of helps you understand some distinctions, but this one's going to state things in a factual way that kind of is just going to reinforce what Google just went over there with how the system plays the idea of handling your bond through that beneficiary title. And basically, it's going to say here, and then, this is just a baseline definition of subrogation: the substitution of one thing for another, or of one person into the place of another with respect to rights, claims, or securities. Subrogation denotes the putting a third person who has paid a debt in the place of a creditor to whom he has paid it, so as that he may exercise against the debtor all subrogation, substantial damages, the rights to which the creditor, if unpaid, might have done. The equity by which a person who is secondarily liable for a debt and has paid it is put in the place of the creditor, so as to entitle to make use of all the securities and remedies possessed by the creditor, in order to enforce the right of exoneration as against the principal debtor, or of the contribution against others who are liable in the same rank as himself. All right, cool. So with all of this, I hope we're all, anyone who's participating in this discussion is circling the wagons on what we're getting to here with the idea of subrogation, because basically what it's going to outline is this is a great way to handle unjust circumstances that come up mainly with the idea of, what's the word I want to look at here? Anything that's not literally criminal. And we all know that criminal means a crime is committed when a man or a woman, it makes a claim against you, makes a claim against another. That in that situation, we're dealing with a criminal proceeding because a man or woman has been diseased either through life, liberty, or through their own property. That's dealing in law. All that other stuff is you're dealing in statutes and policy. So what subrogation allows you to do is say, well, since no man or woman was harmed in the creation of this bond that you have generated in my name, what I'm actually going to do is, I mean, it's covertly to everyone who's uninitiated, but what I've actually just done is retaken the position of plaintiff in the matter, because all of this whole proceeding is all surrounding credit or capital that my name generated. My being you, the person involved who has to deal with the system.
Yeah, that's always the issue is the name that you use is property of the federal government, since that is the business name. So when you are the beneficiary of that name, which you are at all times, you are benefiting from using the name. So what they're saying is we have a claim against this name, the business name. So you can say, okay, here is just like if you have a business, a financial business. When you're going to file for bankruptcy, your business files for bankruptcy, it doesn't go on your credit because that is not you. It's just your business. So when you're using your money that has, or your funds from the business name, that does not go against you. So what you say is, okay, since you bond for the business, I am going to sign off on this, that you are paid by the business, and we're just going to part ways because I have no business dealings with you anymore. Neither does my business.
Yeah. And the overarching principle that makes subrogation so beautiful actually is it's kind of saying saying to all parties involved, no, I'm not attempting to fight this legal matter. What I am, and matter of fact, you should always use this or something to this effect when discussing these issues with those entities, is claiming yourself as the holder in due course for the account in question. When they ask you to claim a name,
That's
tough. they want you to say yes. Like, are you? I won't use my name. Are you? John Doe. You're like, if you say yes, well, guess what? You have to take all the penalty of pains that have come with what they've drawn up for John Doe. Now, if they say, "Are you John Doe?" the right answer would be, yes, I'm the or just I am the holder in due course for the account in question.
Yeah. Do not say yes. Do not say yes.
Yeah,
yes
don't say
is
yes.
an agreement.
Yeah, don't say yes.
Yeah. You always respond with what we talked about. The most powerful words are yes and no and like law. So you do not respond with yes or no unless you absolutely understand what you are agreeing to. Because remember, when you say that, you are agreeing one way or another, yes or no. So do not agree to anything unless you understand completely what is being said.
Yeah. And don't allow them to try to treat your succinct answer to their question as opposition. Feel free to restate yourself.
They will
just understand that you're operating on your paradigm.
A lot of times what they will do is try to force you, or I won't say, because they can't force you, they will try to coerce you into claiming something that you do not believe in or want to claim through storytelling and story time and tall tales of other cases, because that is their most widely used form of coercion is through telling you a story about who has been harmed by them. Like they'll say, oh, somebody else tried that one time and this is what happened to them. Well, you are not that. So they are telling you about a story that is not relative to what you're doing right now, because you are not that man. So be mindful of the fact that coercion is a great tool, and so is fear.
Yeah. Those are the favorites. That's the greatest hits right there. But yeah, so yeah, just understand what your position actually is, as you are actually the creditor to the entire matter that's going on in the courtroom. Anytime there's no other man or woman across the aisle there in a position of plaintiff to claim actively you've transgressed against them in some way that interferes with their life, liberty, or property. So now at that point, you're in a totally in-house situation where all the parties around you have created legal cap or actual capital in your name. Yeah, go ahead. And matter of fact, it begins at the moment you say, I'd like to invoke my right to subrogation. At that point, don't let them look at you confused. Like, this is what they'll like to do to you. Because now it's like, oh, you're talking some imaginary language. You don't understand. We can't comprehend what you're saying. Make it comprehensible. Are you a judicial official? Do you understand the language of the courtroom? I'd like to evoke my right to subrogation. The magistrate knows exactly what that is. Don't let them play coy, or because they'll make that little smirk face and like, what, and like Google just stated, they'll start to tell you tales about all the reasons why you shouldn't do what you have every right to do, because they understand that if you could do it eloquently, that they're in trouble and the jig is up. And that's when you get those special court days and times where no one else is allowed in the room.
Yeah, those court dates are always fun, because you're literally the only individual in the courtroom. They have made sure that all the cases have been heard for the day except yours, no matter what the offense is. You could get a jaywalking. They will wait till everyone is gone and out the courtroom. You have gone past the time of all the criminal proceedings, where they actually had someone who committed a crime who was being tried for some years, and they'll wait for that to be done, and then be like, okay, now we're going to take you. And that's when they have a recess before it also, to make sure they have all their ducks in a row and make sure they have all their legal citations that they want to use and bring up handy and by them. And you will usually see them usually have a stack of legal dictionaries, law dictionaries on the table. There will literally be a stack of law dictionaries on the table and case law for like literally probably around like 5 to 7 books of how they're going to try to handle this just for you, because they will never crack those books open until they get down to yours.
Yep, and that's why rule number 1, you want to be impeccable with your word, because everything they do from that point forward, once they sequestered you into a chambers onto your own, now it's all one big boogeyman session. They just they're going to throw everything at you to make you try to fear going forward. Because if you press on, if you can somehow be diligent and stick to your word, the whole charade just falls right there. And they really, really don't want you to cross that threshold, because they don't want it to be observable the way in which they are playing onto the trying to twist legality to bend you out of lawful standings.
One point I would like to make clear: court proceedings are always public venues. The courthouse is your building. It is a public building, so you have all the rights to review all the cases that come before the public. By making sure all the cases have been heard, they take out the public from the view of the case itself. So when people talk about, you hear them on the internet, oh, I've never seen this document, I've never seen the paperwork, this has never happened. They make sure as a point to have no one in the courtroom. So the public has left, because what happens when you go to court? As soon as your time period is over, everyone leaves, right? So everyone has been left the court. So yes, anyone can see this, but they made sure that no one wants to stay there and view it. So anytime you go to court, if you have time, I've done this. I literally walk into courtrooms. This is what I do just for fun. I walk into courtrooms and watch all the court proceedings for the day if I have time for that day. If I have a free day, I will go there, sit down, and watch. And when you get to the criminal cases too, especially, they will ask you, do you have any interest in the case that is right now? And my complete understanding will say, no, but this is a public case. Is it not? Not respond, they will just walk away. Because there's always a bailiff that comes over and asks you, are you pretty much trying to coerce you and saying you're not allowed to be here? So it would behoove you to have multiple people come and view what your proceedings are, rather than go by yourself. Because the more eyes that are on the court, the less likely they are to commit fraud or to do things that are would institute a judicial complaint. So always remember that this is your court. It is not a judge or a magistrate. It is not an attorney's. It is yours as a man or woman. They will sell you citizens are not allowed. Well, great, because I'm a man. So I don't know where they are, but if you find them, tell them, they got to go.
Yeah. Well, if you're a man or woman free born on American soil, you have all rights are bequeathed upon you with impunity. Like what did it say? Unlimited right to contract. You choose the contracts in which you participate. They try to bear down the contracts onto you. What do you? So Google, someone in the chat's got a question for you. Oh, you're muted.
I see the question. What do you say when they say not allowed? They do not say not allowed. That's one thing they will not say, because a magistrate does not want his ruling overturned by another court, because now he has overstepped his bounds. He has to act, especially if you claim, or if they try to say something like that. Are you acting under your oath to the Constitution, under your official oath? Because you have an oath of office. Every magistrate has an oath of office where they have to do things by the Constitution, regardless of what the legal system says. The law says different. If the law is different than the legal system, the law is superior, not inferior. So they have to do everything in accordance with law. So if someone tries to say that, are you acting under your oath? Because then you can claim there's a whole nother issue about, claiming a violation of oath of office, their bond claimed, which is a financial gain for you, and means they can no longer have that job or no longer ever seek it again. But that's another. We're going to get into that later. But we're going to make sure we stay on the subrogation side.
Hey, well, now you did a good thing right there when you brought up the bond, though. I wanted some more time for me, because so people might not understand why what I was saying is fact in the way that subrogation is dealt with. And that's that idea of, a bond is brought into court. And let's talk about what bonds are. Basically, bonds are financial or compensation that's let's just call it compensation. It's compensation brought in by the claimant to avoid injustice against the person they are going against in the courtroom, because all decisions are made after the court. Like, let's say the party making the claim wins the case. They get their bond back, plus they receive the damages that were awarded by the magistrate or judge. Whereas if for some odd reason an injustice was done upon the defendant through the legal matter, they could then come back and claim the bond as payment for their damages if the judge and all parties involved were to do injustice through the courtroom. It's there as an insurance policy. So here's the thing. So who brings the bond? Oh, well, I just said it. The prosecution, right? The claimant has to bring the bond in. Even if you do small claims lawsuits, you'll find that oftentimes you're asked to bring in a bond if you're the one making a claim. And so every time the state does this, there's a bond every time they do it. And who brought it? The prosecuting attorney. They could be the state's attorney. It doesn't matter. Whoever decides they're going to hold that mantle when they take you on, that person brought the bond into the courtroom. And when you flip yourself into being the status of the creditor, now that person's liable for damages. So if you know how to call out all matters going on in the courtroom, they better tread lightly, because now they're on the hook for damages personally through that bond, of course. So basically what subrogation allows you to do is to offer a bit of a look. I don't engage with the state. So what I'm going to allow you to do, I'm going to allow so if there's no other man or woman willing to make a claim against me, since this is all just, at this point, really it's all policy. If the state is the magistrate, they're the prosecutor, they're the defendant, I'm the odd man out who has no interest in this matter, and you're using my name to create that instrument. So I'm going to say, I'm going to claim my proprietary status towards the name that created that instrument. And I'm going to say to you, look, since all this, you got all this kerfuffle here, go ahead and use the bond money that you brought in to take care of all damages involved. Everyone's healed and remedied because no other man or woman has a claim against me at all. So y'all walk away with the money you already generated by the fact that we're all standing in this room. Let's just shake hands and call it fair game. Because what I'm not going to do is defend myself against the claims you're making here. I'm not going to participate.
The reason you don't say that I'm not going to defend against anything that is being said here is that you cannot defend against an inanimate object, something that is not real. Dictionary individual that they are using is not someone you can go against because you can't bring them to the stand.
Yeah, you can
so
never
if
call
you
them in
can't
the
bring
claim.
them to the stand, you can never call them in the claim. Yes, you cannot bring them to the stand. How are you going to fight that? Well, we say the state says you did this, that, or the third. Well, can I call a state to the stand? No. So how am I supposed to defend myself? If they cannot show someone who is actually claiming something against you, then you know this is all imaginary. And if it's all imaginary, well, go ahead and I'm gonna use my imaginary man, that name. That imaginary man is on you. This imaginary man is on me. So since everyone here is imaginary, let's go ahead and let imaginary take care of imaginary.
Yep. Holding on to your claim to your private capacity by not involving yourself in a public matter regarding fictional entities. You don't want to make a statement in the affirmative or negative regarding anything. You're neutral. It's over there. It's in the paper world. Literally, all this stuff happened on paper. So, as it goes with the matter of subrogation, we can talk about a couple of so what you see here is just a manila filing. Yeah, so if you ever you want to deal with the courts, you want to keep immaculate records, really good. Yeah, so I happen to have some of that background here, so I'm gonna try to censor some things. I'm just gonna kind of show you the fact that the document exists. I'm not snitching on my notary or myself, but what you'll see here is a statement of fact. It's basically just saying that I'm the individual. And here, actually, let me read it off to you. So what it says here is lowercase I, the man known as John Doe, have not knowingly and without being under duress entered into any contracts with any government agencies or companies they work with. It is your duty by oath to abide by the Constitution and law to rescind any and all assumed contracts there may be. Common law of the land, is the only law I live by. Signed, the man, John Doe. Publicly notarized to be a statement of truth. Are you allowed to tell me I lied? So that's a strong start right there. That's how you start nailing it in. You want a strong foundation to your matter.
One point. The reason he says that is because when you have something notarized that is agreed to, that's what a notary means. It has been agreed to that this is a factual document that is on the records and our court or system has agreed to it, that this document. So now they have to try to refute the facts that they said are facts. How do they do that?
And that, my good people, is the beauty of filing paperwork before you ever even walk into a room. Always a fun statement whenever you can say to themselves, when you can say to the people, as you know, berating you with questions that you're never under any duty to answer. It's in the paperwork, because you can't argue. Why are you arguing with me? Why are we here to argue with something I've already made fact for you? It's on the record. So it's funny. All right. Yeah, I don't even mean to do this, but
I just want to say that one of the best feelings in the world is to say anytime they start trying to berate you or questioning you or threaten you, it's like all documents have been filed. It's in the paperwork. All documents have been filed. It's in the paperwork. Are you claiming that this, that, and third? All documents have been filed. It's in the paperwork. So they have to go through and read the paperwork, because a lot of times what they'll try to do is not read the paperwork at all and try to, like I said, coerce you into saying something or doing something that is not in the paperwork. Because the paperwork is pretty much your shield from them, because that is forcing them to fight amongst themselves. This is like he was saying with segregation. You are not part of this. I, as a man, am not part of your battle. That's a family fight. When you have a family fight, the outsider doesn't get into it. He doesn't get involved because that looks pretty bad. I'm not going to go ahead and step in there because I don't like, hey, I'm cool with your mom. I'm cool with your dad. I'm just going to step myself out of this. I'm going to let y'all have this. Hash that out.
Hey, I put it to you like this. When Frodo goes to battle Sauron in the land of Mordor, I don't get invested beyond. I just observe. I read the book and I enjoy the tale. I don't suit up. It was an interesting story. Thanks for sharing. But yeah. So that's really, you want to be able to designate your territory. Like, and I loved how you called it a shield, because that's literally what this language, once you file paperwork, so what they'll do in court is that paperwork's ironclad. Oh, let's press him and make him or her make a statement that invalidates all that paperwork. And even if it does or does not, it can't actually invalidate the paperwork. Once now you feel, I said something, and then they start to attack you based on what was said in court, you might as well toss all that paperwork out. Why'd you spend all the time filing it? Now you feel railroaded because you didn't stick to what already freed you from the matter. So yeah, that's why you should have extensive paperwork on file with things, because you're going to want to be able to refer back without having to try to without incriminating yourself in any fashion. Paper is good for that.
Go
ahead.
I'll say one thing, if you study law enough, if you go to enough courtrooms, if you practical application, if you get into enough practical application, you will find that you do not say anything in court you do not want to talk about. That is a pretty much a maximum law. Do not say anything in court. Any sound attorney and legal professional will not say anything in court that you do not want to talk about. So if they try to, or if they're trying to coerce you into saying, remember, you do not say anything in court that you do not want to talk about. You always have rights. Life, liberty, and pursuit of happiness. You have these rights. These rights are not given by any court system. They're not given by any state. They're not given by federal government. They have been there long before there was ever such thing as a federal government. So you have the right to not incriminate, to not say anything that is going to go against, that is not going to be what you believe. So just don't say anything. Like you said, it's all in the paperwork. I don't need to talk. I've already talked. I talked with my pen.
All right, you just gave me an amazing segue, because right here, if you can see the heading of that document, there you go. It's an affidavit of truth. So let me give you a little taste of this, and this is so you can understand the power of having your words on the record before you utter a single phrase. So here it is. Be it known to all who call themselves "quote unquote" government, their courts, agents, or other parties, that I am a natural, freeborn, sovereign individual without subjects. I am neither subject to any entity anywhere, nor is any entity subject to me. I neither dominate anyone, nor am I dominated. I am not a person as defined in statutes, when such definition includes artificial entities. I refuse to be treated as a federally or state created entity which is only capable of exercising certain rights, privileges, or immunities as specifically granted by federal or state governments. I may voluntarily choose to comply with the laws which others attempt to impose upon me, but no such laws nor their enforcers have any authority over me. I am not in any jurisdiction, for I am not a subject. I am not of subject status. Unless I am willfully harmed or violated someone or someone's property without their consent, I have not committed any crime and am therefore not subject to any penalty. Thus, be it known to all that I reserve my natural right not to be compelled to perform under any contract that I did not enter into knowingly, voluntarily, and intentionally. Furthermore, I do not accept the liability associated with the compelled and pretended benefit of any hidden or unrevealed contract or commercial agreement. As such, the hidden, unrevealed contracts that supposedly create obligations to perform for persons of subject status are inapplicable to me and are null and void. If I have participated in any of the supposed benefits associated with these hidden contracts, I have done so under duress for lack of any other practical alternative. I may have received such benefits, but I have not accepted them in a manner that binds me to anything. So I didn't even finish the first page. So it kind of goes on with this for a while. I'm speed passing y'all through it so you can understand. So just understand there's a document out here, and I literally use a template. So these things exist out here if you search. We can have broader conversations on that. We plan on implementing ways in which we can do that. But for right now, understood that these things can be searched out. We'll probably circle back to this information in later casts. So it then goes on to label the birth certificate. The fact that a birth certificate was issued to me by a local hospital or government agency when I was born is irrelevant to my sovereignty. No status, high or low, can be assigned to another person through a piece of paper without the recipient's full knowledge and consent. Therefore, such a piece of paper provides date and place information only. It indicates nothing about jurisdiction, nothing about property ownership, nothing about rights, and nothing about subject status. The only documents that can have any significance as it concerns my status in society are those which I have signed as an adult with full knowledge and consent, free from misrepresentation or coercion of any kind. So that means I could even be an adult, but if I don't understand all the terms that apply to it, and then you try to wrangle me into court on something, and I then find out after the fact, I can just simply bring up in court at that moment, man, I signed that contract at a point in which all details were not made clear to me. And that's a perfectly acceptable leg to stand on.
Yes, that is always the law of contracts. Law of contracts require consent, or what the best term for it is consideration. Now, consideration does not mean that you thought about somebody else's feelings. You know, that you were thinking about them when you did something. That is not consideration. Webster's has no place in law. Webster's has no place. Black's Law Dictionary has place in law. You have to read the words from a law dictionary to understand the words in law. You cannot use Webster's and step into a courtroom and think that, oh, I know everything that's going on right now. You are basically a child, because you are now just you have just now started learning words. They will tell you words and you be like, I don't know what that means. No, you don't. Because consideration is both parties are getting something out of the deal. And both parties are getting something out of the deal. No full knowledge of what entails in the deal itself. So complete knowledge. So if you can't say, I came back with a contract and edited, and now this is binding. No, because I never signed that contract. My contract I have with you only says one thing. If you wanted to choose to edit it, well, then the contract we have is no longer valid, and we need to redo another contract. I have to agree to it. If I do not agree to this new contract, well, the only one you can claim is the one that we do have.
Man, what if I told you that consideration has like a 2.5 page shelf in the Black's Law Dictionary? The one term, because they have to cover all the variants.
Wow.
All right, so let me just give you the literal stock. Here's consideration in a nutshell, so you don't have to read 2.5 pages. Maybe you should at some point. Here's this. Something such as an act, a forbearance, or a return promise, bargained for and received by a promisor from a promisee, that which motivates a person to do something, especially to engage in a legal act. Consideration or a substitute such as promissory estoppel is necessary for an agreement to be enforceable. How many agreements are you in right now, or do you suppose yourself to be in, with an entity known as the U.S. government with no backing in some sort of guaranteed return? A question you may want to ask yourself.
Always a question you want to ask yourself: what am I getting out of the deal? Because everything is a deal. What am I getting out of the deal? So there is no consideration if you do not get anything out of the deal, which literally makes all contracts without consideration null and void, because they must have consideration for it to be a valid contract or valid agreement, whichever one you want term you want to use. For it to be valid, it must have consideration. So you have to be receiving something in order to give somebody something. So when you have any say that, oh, you have what they call it, privilege. That's what they call it. When you have a quote unquote privilege, what privilege, what are you getting out of this deal?
Yeah. Oh, so actually, let's use this as so what I wanted you to understand about that affidavit of truth, that little item about the birth certificate was literally item 1 of 11. All right, that was item 1 of 11. So I just want to go through those really quickly with you. I really delineated the birth certificate one because that was very important to understand. I'm gonna kind of gloss over these really quick because basically what this is you need to understand that this affidavit of truth is pretty much just a refutement of all the things that they're going to try to jump down your throat with inside the courtroom. So I see the oh, there it goes, the jump back up. I was about to say the overall signal looked like it had gotten real low. So I was just hoping I was still being heard.
Yes.
All
sir.
right. Awesome. Great. So let me jump right into this. So number 2 on that list is the use of national currency to discharge my debts. I have used these only because there is no other widely recognized currency. Oh, that's another topic for another cast.
Wait a second. Remember,
Oh, go ahead.
we're trying to stay on subrogation.
Yeah,
We're
I know.
trying to stay on subrogation.
No, this is all related.
Okay. All right.
Going on to number 3. The use of a bank account. If there is any hidden contract behind an account, my signature therewith gives no validity to it. The signature is only for verification of identity. I cannot be obligated to fulfill any hidden or unrevealed contract whatsoever due to the absence of full disclosure and voluntary consent. Depends. What do you know about fractional reserve banking? Look into it. All right, going on. Item number 4, the use of a driver's license. There is no real need for me to have such a license for traveling in my car. However, if I am stopped for any reason and found to be without a license, it is likely I would be unduly harassed and penalized. Therefore, under duress, I carry a license only to avoid extreme inconvenience. It's kind of like a dog treat for a Rottweiler. Calm down, boy. Here's what you need to do what you do. All right, here's state number 5, very important as well. State plates on my car. Similarly, if I have registered my car with a state and carry the state plates on it, I have done so only because to have any other plates or no plates at all causes me to run the risk of police officer harassment and extreme inconvenience. You can't really explain these things to simpletons. So that's why papers like these are really good. You can just hand it all as one, docket for the said simpleton to learn the law they pretend to enforce. So the use of a passport is in here. No real need for me to have a passport other than associated permit or other associated permits and visas to travel. That vaccine passports, that'll be a thing. I have the right to travel without hindrance wherever, however, and whenever I wish, so long as I do not encroach upon the private property of others. Though without a passport, my right to travel is unduly hindered. Therefore, under duress, I only use a passport to prevent extreme inconvenience and to ensure that I can travel from one country to another at all. So I'm tacitly not complying with your contract, just giving you a thing that says, here's the thing that you guys use. Let's keep it convenient. But at all, I have unlimited right to contract. All this, right? Good. Moving on. Past filings of tax returns. Because such tax returns were filed under threat of duress and coercion, and no way two contracts were ever signed with full disclosure, there is nothing in any past filing of tax returns or payments that created any valid contract. Therefore, no obligation on my part was ever created. Past enrollment and voting, same sort of thing. Citizenship. The claiming of citizenship, because we already talked about what a 14th Amendment citizen is. This is just saying that although your documents only give me this option, I always ascribe myself to being, we are the people, the third word. I'm the third word in the Constitution. We don't talk to me about things that happened in the 14th Amendment. If I ever capitulated to anything stating as such, it was simply for convenience. I don't even have to read all that to know that's what it said. And I think that was number 9. There's 2 more. I think my paper slightly got out of order. What are the last? Here it is. Oh, this is kind of beautiful. The Constitution itself, the document supposedly setting forth the foundations of a country and its government, has no inherent authority or obligation. A constitution has no authority or obligation at all unless a contract between 2 or more individuals, and then it is limited only to those individuals who have specifically entered into it. At most, such a document could be a contract between the existing people at the time of its creation, but no one has the right, authority, or power to bind their posterity. I have not knowingly, voluntarily, or intentionally entered into any such constitution contract to oblige myself thereby. Therefore, such a document is inapplicable to me, and anyone claiming to derive their authority from such a document has no jurisdiction over me. And lastly, is use of semantics, which basically just says the same thing, but through word, verbal gymnastics. Oh, man, you know what we got to do, right? I'm sorry, I did all that. That was all 11. You know what we got to do. Hey, Bach.
Yeah.
Go ahead and drop that Hale versus Hinkle form one more time.
Alrighty. Here it is.
One more time for the one again. Let's get it.
All right. Instagram. Come on, pull up for me, baby.
Did you catch that part about the Constitution?
Yeah.
Because I feel like the dude in the yellow suit right now. Hold on. Okay. I'm going to make sure my paper's in order again. All right, cool. Never know when you'll need them.
That's fact.
As they say, it's better to have it and not need it.
Yeah. Exactly. Always better to and not need it than to need it and not have it. You can do a number of things as far as making sure that you are they understand your standing as a man, or you can choose to be a citizen, or whichever one you decide. Not my place to tell you how you should go about your life. I just always want to make sure that everything is on the record, and duly noted by both parties. So I make sure they have their copy. I make sure I have mine.
Facts on facts. All right, so Elliot, yeah, look at what you're looking at right here is Hale versus Hinkle once again. I know we opened the cast with it, but these things don't ring out if you don't keep constantly. You know what I was thinking to myself? I used to be a computer science major in college, and they had this function called a pointer, and basically it was a function you would type out that would allow you to reference another main item. Basically, it would kind of always run the system back through a main rinse, wash, repeat thing, where it's like, oh, this statement here alludes to this main principle here. It's funny how law and computer science can merge themselves underneath certain principles. So, that affidavit of truth points you right back to good old Hale versus Hinkle here, the case that's been cited probably in the neighborhood of 2,000 times and has never been properly refuted in a court of law, which tells you right there that the individual may stand upon their constitutional rights as a citizen even to break out of any contract with the government that they've been in unknowingly. You're entitled to carry on your private business in your own way. Your power to contract is unlimited. You owe no duty to the state. I'm pretty sure that's what my affidavit of truth just said. Oh, wait, I'm sorry. Here's the most important part that they made there. Quote unquote, his rights. I mean, his being any man, woman, or child free born within the region of the United States of America. His rights are such as existed by the law of the land, common law, long antecedent, long before the organization of the state, and can only be taken from him by due process of law. All right, there we go. That's all I needed to squeeze from that. I'm just hoping this really seeps into your, your mental here.
Group. That brain housing group. You gotta make sure it sinks into that brain housing group.
Facts. Oh, should I cover really quick the 11th item about use of semantics, just so people don't get confused about verbal gymnastics?
I think it's better just to stick with basics, mostly because unless you comprehend the words that are being used in a document, you can never really truly understand it. So when you say you understand or you agree, you don't know what you're agreeing to or saying you understand. You have to break down every single word, and why we take the time to break down the words of documents itself. Wording is everything. All words matter.
Exactly. So I'm sorry, I'm just gonna give them a little blurb of this, just a little bit, because I want people to feel, because like we talk about being immaculate with your word and stuff like that. And you're like, oh no, I'm not ready to step in the court of law. No. All right, here, understand this and know it to be like factual when you're making these sort of dealings with people. Largely premised on everything we've just stated there, especially covered through Hale versus Hinkle. But here's just a little piece of it. There are some immature people with mental imbalances, such as craving to dominate other people, who masquerade as government and call noises and scribbles that emanate from their mouths and pens. They call that stuff the law, which must be obeyed in their, just because they alter definitions of words in their quote unquote law books to their supposed advantage doesn't mean that I accept those definitions. The fact that they define the words person, address, male, resident, motor vehicle, driving, passenger, employee, income, and many others in ways different from common usage so as to be associated with subject or slave status means nothing in real life. So that's the underpinning principle here. All right, good. Just want to make sure that came.
The end of what he was trying to meet, what he was very succinct, probably trying to say. This is what I'm trying to say. Thank you. Is that no words apply to you unless you want them to. Those words that they use in business terms and nature do not apply unless you want them to.
Exactly. Contracts are tailored to fit as long as you understand what's stated within.
Yeah, but like what we were trying to say, have practical application of it. Everything, definition, how it applies, practical application. Definition, how it applies, practical application. We gave you the definition, how it applies in a courtroom, and then Plain Sight showed you practical application of it from his own practical application of it.
Yep. So because that affidavit of truth was probably the strongest thing out of that grouping of things for being able to assert your right to subrogation. I'm not going to dig into these documents. I just want you to know I got to cover a name because I don't want to incriminate anyone. But like for instance, I sent. There we go. So there it is. All right. So and there we go. We'll cover some stuff there. All right. Yeah. But basically, if I redact all that, what you're going to see here is that basically I'm contacting the court magistrate to let them know that a representative of the state, you know, in the uniformed officer who I was dealing with, has asserted a false conclusion of law into the court system, and that basically there's no fundamental power to the process that's being enacted here. So that gets sent directly to the judge in his chambers so that he's to understand what's coming his way upon, you know, entering into any mitigation of the matter presented. So that's that. So you state that off the break. Then what you want to do is you actually want to send the same thing to the court clerk there. So you're going to have their attention at the top of that page there, and you're going to make them known that they need to be able to give you any documents that create the presumption that John Doe is a resident of the state. They need to they need to produce. So basically what I'm going to show you right now. Okay, I'm not going to show you the whole thing, but what you'll see here is a 37 item list of things that they must produce in order to go forward with their proceedings. Here's a major hint. They can't do it. They cannot do it. All right, let me here, I'll just read you a couple of them. They got to create documents. They got to show documents that show that revenue taxable activity, that traveling is in commerce. They have to prove that traveling is in commerce. You've already definitely defeated them by item number 2 if item number 1 didn't get them. They gotta show documents stating that watch this one. This is fun. Any documents record under the control and other than documents obtained by fraud without full disclosure that establish that this case as an adversary proceeding pursuant to bankruptcy rules Section 7 or an interim proceeding. Yeah, you know where I'm going with that.
Just you don't need to give them all of it right now. Like I said, we wanted to cover subrogation as much as possible, and give you a definition, how it applies, and the practical application of it. When you step into a courtroom, as I said, subrogation is substituting in your business name for you, because that is what the court is doing in. It only deals in fictional things because everyone in that courtroom is technically a fictional body except you, since everyone is acting as someone who does not exist. An attorney for the state is a person who is acting on or for someone who does not exist. A magistrate or judge is for the court, is for the state also, which the state does not exist. So he's acting for someone who does not exist. So you have to make sure that also a fictionary character in this novel and act as a fictionary character and write your what you want your fictional character to do out for them. So your subrogation is your right to subrogation is you saying, okay, everyone here is fictional. This is what my fictional man is going to do. He's going to just write this out, and we're going to all pretend that we went through this whole play where you said this and the attorney said that and I said this. So, and the ruling was this amount of funds for the bond is what we agreed upon. Right? Right? Brick.
Yeah. Yep. So basically, you allow their machinations to roll as they go. Ultimately, the magistrate that understands that you're in full understanding of the process you're dealing in is ultimately just going to end up letting it roll because they got what they wanted anyways. Once they created that bond, they received what they wanted. So all the other stuff they do to people is double dipping. They're double dipping to try to, it's like playing the slots. They're playing the game, except the slots are rigged to go off and have them win every time. Why don't you just be that one machine that only gives them their base payout? That they put their ticket in, they just got their money back out.
Yeah. Like I said, we try to make this as concise as possible. The fact that we are limited in time. You have to understand that when you are talking about constitutional law or just law in period in general, the between what we do and what we say and everything else encompasses constitutional law and contract law. So you're literally taking two forms of law which are very different and trying to break them down into a period that can be understood by everyone in a short amount of time. So it's pretty much, like I said, giving you information that is learned throughout years of in a very short time. It's not something
Giving
that
the nitty gritty.
take each one individually. You have to take each one individually. You have to do contract law and you have to study constitutional law, which they really don't give any more law classes in because that is, you know, pretty much destroys their whole job. So it's hard for us sometimes to try to make sure that we get both sides out for you, but we try our best to make it coherent and digestible. That all the words that go into the play that is a courtroom. Because if you actually look at the original terms for a court, it is you have to put on a good show. It's like a theater. So when you were in an open court, you had to put on a play. So when just like when you said anything in a court for as a jester or in a court, you had to stand on your stand high so everyone could hear you. So you had to make sure that you had a good show. So all these things have to go into this whole entire dynamic of the play. So we're trying to give you the words of Shakespeare so that John Smith can understand.
Yeah, you just brought up a good. You just brought something into my memory. So when D Wade retired, you know, and you think about courts. I'm talking, of course, a basketball court here, and someone had asked him a real deep. It was kind of a deep question. They were just basically like, "Hey, man, you know, what's most powerful in your mind when you remember the game of basketball?" And he was like, and this was like, it blew my mind away. He was like, you know, I think back to those moments where it's in the clutch. You know, I got the ball and I've got the crowd in my hand the same way I got the ball in my hand. He remembers that his primary role in that whole thing is he's an entertainer. And I was like, yo, I've never heard any athlete say that. You know, it's court, performer. He lives for those high threshold moments of being the Maximus entertainer. I was like, wow, he gets it in such a sense.
Put on a good show.
Absolutely, man. As usual, man, y'all did it again, man. Great show, man. Definitely a lot of information, man. That was super tough. That was very detailed in how to proceed, man. Just like you said. We just want to thank everybody for tuning in as usual, man. Shout out to the people who left us some comments and asked some questions. Please like, share, turn on our notifications, and we're gonna just keep bringing you great content, man. A Google Plain Sight, man. You guys are great, man. Thanks again, man.
Hey, man.
Like you said, do it because we love y'all.
Facts.
Absolutely. Y'all know what it is. We'll be back next Tuesday. Make sure y'all tune in. Make sure y'all follow, share, like, comment, man. And thanks again for tapping in with us this morning. Peace.
Peace.
Yep.